Good morning, everyone. It's a true pleasure to be back in Nalsar talking to all of you. I think Professor Murli Kannam heard me speak at Bangalore on the Sukanya Shanta judgment, and then he was very keen that I should also speak on more or less the same ideas here. So when I prepared the background note and sent it to Teja Lakshmi here, I said the backdrop will be the Sukanya Shanta judgment. And as it usually happens, all that plan has changed. So I'm going to start on a different note today. So I don't know what the speakers yesterday adverted to, but in the context of dignity, there has been always, I would say, a kind of a confusion between dignity as a value and dignity as a right. So, and judges constantly encounter this confusion. So, in the earlier phase of the Supreme Court's functioning, let's say up to the 70s, they were referring to dignity as a constitutional value, forming the very core of the fundamental rights. And you find that being adverted to not only in A.K. Gopalan, but even in Indian Express newspapers, where they're talking of wages for working journalists. And there's an interesting judgment in 1962, where Chief Justice B.P. Sinha dissents in the context of the Dawoodi Bohra excommunication practice, which was outlawed by the Bombay state of those days, and so on and so forth. And then you have Golaknath and Keshavananda Bharati. So when you advert to the basic structure, again, there's a reference to dignity. But all of this is in the context of dignity stemming from the preamble being a constitutional value. In fact, the phrase used in the Constitution's preamble is fraternity assuring the dignity of the individual. So it's not fraternity per se, but fraternity that works to ensure that individual dignity is not violated. So they've used this in the 70s to explain the context, explain what is it to lead a life with dignity. So then that comes into Article 21, when you start reading Francis Corelli-Moulin, or even before that, Sunil Batra. I'm not dwelling on all of this, but just to explain to you that when they find conditions in which prisoners are kept, which they find is degrading to human dignity, they draw on that to say there is no question of a right to life if it is not a life with dignity. So then the contours of the right to life, those are explored in the context of dignity as a constitutional value and how life would be meaningless without a life with dignity. That's the classic phrase in Francis Corelli-Moulin. What has happened in the recent phase, the last phase, I would say 21st century, in the context of recognition of the right of persons with different sexual orientation, there's a full arc. And I should, at the risk of being immodest, say that it started with NAS Foundation, where one of the main pillars of the reasoning in NAS Foundation was the right to dignity, the right to a life with dignity. And that was picked up in one sense in Nalsar judgment in the Supreme Court, although there was a setback when NAS was reversed by Sudesh Kausar. But in the Puttaswamy judgment, which is the privacy judgment, there's a very lengthy discussion on explaining, and this is Justice Chandrachud's judgment in the privacy case Puttaswamy, 9-judge bench. There's a lengthy discussion on why NAS is right and Sudesh Kaushal is wrong. And much of the discussion centers around this dignity as a constitutional value and why it is necessary to develop around this constitutional value of dignity to explain full personhood of persons with different sexual orientation. And from Puttaswamy to Navtej Johar was just a corollary, I would say. It became an easy task for the Supreme Court, whether it was Navtej Johar or Joseph Shine, to use the same reasoning to say you cannot criminalize consensual sexual acts between adults in private. Likewise, adultery, criminalizing adultery, was illegalized by saying that characterizing the woman as a property of a man, or saying that she doesn't have an identity of her own, is violative of the right to dignity. So there's a whole arc that starts with Nas and goes up to Joseph Shine. But as we all know, not all judges think alike, and we don't have one Supreme Court, as in some countries, particularly the US Supreme Court, where justices sit en banc. We have several Supreme Courts. And that becomes very clear when we look at some of the cases that I'm going to discuss today. So let me begin by saying that the centrality to dignity, which is spelled out in the International Bill of Human Rights, whether it's the Universal Declaration of Human Rights or the ICCPR, the ICESCR, that has continued in some of the written constitutions. And the best example is the South African Constitution, which separately defines the right to dignity and separately defines the right to privacy as well. Now, in our constitution, and this is where I think I want to make a definite point, because I find that legal scholars have perhaps missed something. I found in one of the pieces that a reference was made no doubt to the word dignity in the preamble, fraternity assuring the dignity of the individual, and also to Article 39E, which is in the directive principles, which says that the health and strength of workers, men and women, and the tender age of children are not abused, and that citizens are not forced by economic necessity to enter avocations unsuited to their age. And F, 39F, that children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, that the childhood and youth are protected against exploitation. The other provision which expressly refers to the word dignity is Article 51 capital A, where in 51AE, it says to promote harmony and the spirit of common brotherhood amongst all people of India, transcending religious, linguistic, and regional or sectional diversities, to renounce practices derogatory to the dignity of women. But it would be a mistake to think that these are the only references to dignity in the Indian Constitution. Because if you go back to history, if you know the Vaikam Satyagraha, the Mahat Satyagraha, about rights of Dalits to enter places of Hindu temples of worship, that was very much in the minds of the constitution framers when they sat down to draft one particular article, which is Article 15. Article 15.2 is entirely about human dignity. I'll just read that because I think we need to revisit. This is a classic example of horizontality of rights. No citizen shall, this is how it reads, no citizen shall on the grounds of only of religion, race, caste, sex, place of birth, or any of them be subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment, or, and this is important, the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly and partly out of state funds or dedicated to the use of general public. So if you go back to our legal political history, you will find that much of the struggles of the Dalits were around these issues of course, untouchability, which I'll come to in a minute, but also access, denial of access to public places, including bathing ghats, wells, tanks, roads, and places of public resort. How many in this audience have heard of this documentary called India Untouched? Okay, I'm glad that at least 3. So I would urge you as part of your dignity law course to look at that documentary and have a discussion, because it tells you how caste is the elephant in the room as far as India is concerned. And caste pervades all religions. So this whole concept of the hierarchy, social hierarchy through caste, is to be found in every religion in India. and I'm talking of Sikhism, Islam. We don't know enough of Buddhism, but certainly Christianity, Islam, and Sikhism, in their social practices, still strictly and rigidly maintain the caste hierarchy. And that documentary brings it out. Of course, it talks of the Hindu religious fold and the caste practices there. But this is a very important point it makes. And the documentary also makes this important point, which Ambedkar was at pains to point out in the Constituent Assembly debates, of the concept of what is called graded inequality. So even among the Dalits, the untouchables, there's a social hierarchy. So for instance, the Domes will not marry the Chamars, who will not marry the Mushahars. So you can marry up, you cannot marry down. So these rigid hierarchies have been, preserved. So the other point of discussion for all of you could be the matrimonial columns. So pick up like today is a Sunday, right? So any mainstream paper would have matrimonial columns. So Professor Erin Daly may want to, I don't know if you've already seen it, but if you want to understand what do we mean by graded inequality, so you find castes, subcastes, further clarifications within that. So the whole spectrum of inequality is on full display in the matrimonial columns. So these are very important for us to inform ourselves of the nature of Indian society. Because we'll be making a terrible mistake if we do not see in granular detail what our society is all about. And it tells us something about ourselves too. The unacknowledged biases that we all live with, we've grown with, and our own understanding of a society is informed by our immediate surroundings, right? The practices that we are so comfortable with, like the 2-tumbler norm, right? Somebody comes to work in your place, in your house, to sweep and swab the floor, clean your utensils, wash your clothes. Now, the way those persons are treated in terms of sharing of food or drink, in many households, you'll find that a separate set of utensils are kept for them to drink tea from or water from. And this is something as when we grow up as children, we don't question it at all. We take it for granted. We don't even pause to think that passively you're condoning a discriminatory practice. So once you learn to live comfortably with discrimination of this sort, you'll cease to see what do you signify as a person to the person who's being discriminated against. So these understandings as law students is very, very important, because you can read this as an academic subject, but there has to be at least a degree of experiencing what it is. So the third thing which you could do is role play. Imagine yourself to be a rack picker. Imagine yourself to be a sewer cleaner. What it is to be that. You can only have a vicarious experience. I was told in Nalsar you had sewer cleaners come here and clean the manholes. So when I did the social economic rights course here many, many years ago and spoke about this, some of the students then began to notice that, yes, over the weekend, somebody was coming to clean the manholes here, get into the sewers lines and clean it, and then began questioning it as an undignified practice. So constitutional provisions, to come back to that, Article 15 is therefore 15.2, completely encapsulates the whole concept of dignity as a constitutional value. The other provision is Article 17. I'm sure you've been told about that. This and Article 23 are the only two provisions which are unique to the Indian Constitution, which you will not find in any written constitution in the world, which talks of untouchability being declared an offense. Usually penal statutes declare offenses, constitutions don't. But our constitution in two provisions, Article 17 and Article 23, declare a certain practice to be an offense. 17 says untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. So this was a very clear enunciation by the constitution framers of what I think Dworkin would characterize as a baseline violation of human dignity. Something that there cannot be any contestation about. Because there's always an argument saying dignity is so vague a concept. And it has a very cultural specificity. So what is undignified for one person may not be for another. This is one of the arguments against developing a right to dignity. So in academic literature, which I'm sure you'll come across in your course, you will find this argument put forth that the minute you recognize a right to dignity, it somehow militates against this recognition of dignity being inherent to a human being. Which means if there's a violation of a right to dignity, it's a negation of your inherent dignity, which is not true, right? Once you say being born as a person, you have inherent dignity, it just can't be taken away by anyone. You can have violations of it, but it can't be taken away, it can't be negated. The other problem they point out is competing dignities. Let's take the context of medical termination of pregnancy. Right? Right to choose, pro-life, pro-choice, right? The whole debate, Roe versus Wade, which has come into India today, unfortunately. And that's happened now in 2023, when two judges, women judges of the Supreme Court, deferred after having allowed the woman's right to terminate a pregnancy because she was already suffering from postpartum depression as a result of the first child. And she had come back to the court saying, I can't afford now to carry this pregnancy to the full term. So initially the two judges recognized that and allowed the termination of pregnancy. And the additional Solicitor General walks into the court the next morning with an email from one of the persons, one of the doctors on the medical panel, medical board, to say that the fetus has a heartbeat. And that makes one of the judges change her mind. And when the matter is referred to three judges, the new bench has no women on it. And it says, oh, the fetus has heartbeat, we will not allow this termination of pregnancy. So again, bringing back what was troubling the US Supreme Court into the Indian discourse around medical termination of pregnancy. So it's again, therefore, a contestation between two rights to dignity. If there's an inherent dignity in the fetus, then can that be, squared off against the woman's right to autonomy? So they say if you start recognizing a right to dignity, you will run into these kinds of issues. But there is an answer to that as far as the Indian context is concerned. I'll just come to that in a minute. So Article 17 is one provision which clearly states that untouchability is an offense, and untouchability is all about the right to dignity. The humiliation that you encounter, right? And in the Indian context, therefore, it is not very difficult for people to understand when we talk of dignity, what it connotes. Again, Article 23 is the other article, prohibition of traffic in human beings and forced labor. So the word used in the Constitution is a Hindustani word, begar, always misprinted in many texts as beggar. It's actually begar. Traffic in human beings and begar and other forms of forced labor are prohibited. So forced labor is something that we recognized as violating the right to dignity. Dignity is a value. Dignity is inherent in human beings. So our Constitution definitely maybe doesn't use the word dignity in these provisions, but these provisions are all about that. Article 24 is the other provision. Prohibition of employment of children in factories. No child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. So on these, there was no doubt in the minds of the Constitution framers that they were talking about dignity. Another important provision that you need to notice, Article 25, Subarticle 2, Clause B. 25 itself is about freedom of conscience and free profession, practice, and propagation of religion. not confined to any minority. This is a general article of religious freedom. But sub-article 2b is very interesting. It says nothing in this article shall affect the operation of any existing law, prevent the state from making any law, providing for social welfare and reform, or throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. So this is specifically in light of the Vaikom Satyagraha, the Mahat Satyagraha, where even Nathdwara, the temple entry being barred to Dalits. I don't know how many of you followed the news item of the earlier president of India, previous to the present one. Do you know who he was? Can you name him? Can any of you name the president previous to the present president? Ramnath Kovind, who was a Dalit. So he happened to visit the Puri temple in Orissa. And after his visit, they had a temple cleaning that was undertaken. And this is, we are talking to the President of India. So even in 2022, I think this was 2022, this barring entry of certain sections of Hindu society into temples has continued. And this is very unfortunate because in Puri, if you go today, there is a clear board saying that beyond a certain point, non-Hindus cannot enter the temple. Of course, how they enforce it is entirely a different story. But this continues. This continues till today. But among Hindus to do this is something completely unacceptable. So this is in complete negation of Article 25(2)(b), which encapsulates this right to dignity. Because when places of public worship are barred to a certain section of Hindus, the Constitution said the state has a right to intervene to illegalize it, which is what the problem in the Shabarimala case is all about. Okay, so I'll come to that again in a minute. So with this backdrop of constitutional provisions, you begin to understand that in the Indian context, we may not run into difficulty in trying to identify what are practices violative of human dignity. The best example of violations of what Dawkins would call baseline, by the way, he had two categories. One he said is a baseline violation. The other he says is a bad faith violation. So bad faith violation is cultural specific. So in certain societies, in certain cultures, certain practices would be violative of dignity, whereas it may not in some other society. So that he gives a margin for, but he identifies what are called baseline violations. And according to me, 15 to 17, 23, all talk of these baseline violations. If you pick up the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act, and it's astonishing, I don't know how many of us have paused to even read it properly, what the legislature acknowledges as baseline violations. So section 3 actually lists out, and I'm going to take some time to list it out, punishment for offenses of atrocities. Whoever, not being a member of a scheduled caste or a scheduled tribe, puts any inedible or obnoxious substance into the mouth of a member of a scheduled caste or scheduled tribe, or forces such member to drink or eat such inedible or obnoxious substance, dumps excreta, sewage, carcasses, or any other obnoxious substances in the premises or at the entrance of the premises occupied by a member of scheduled caste or scheduled tribe. So this is a proper legislative acknowledgement of practices that are violative of human dignity. So we don't have to go travel far, which is why I'm saying just look around you and you will find this. With an intent to cause injury, insult, or annoyance to any member of a scheduled caste or scheduled tribe, dumps excreta, waste matter, carcasses, or other obnoxious substance in his neighborhood, garlands with footwear. This is in the statute. Garlands with footwear or parades naked or semi-naked a member of a scheduled caste or a scheduled tribe. Does this still happen in our country? How many of you say yes? That's a good number. I'm glad you are reading newspapers. Forcibly commits on a member of a scheduled caste or scheduled tribe any act such as removing clothes from the person, forcible tonsuring of head, removing mustaches, painting face or body, or any other similar act which is derogatory to human dignity. So this blackening of the face is something that still happens. So you have Khap Panchayats, Katta Panchayats, the so-called informal adjudicatory systems, which can sometimes be glorified or romanticized, but which can be completely dominated by the upper castes. And justice can be made a mockery of by the kinds of punishments that they hand down. I'm not going to read all of them, but some which will shock anyone's conscience, forget judicial conscience. Compels a member of a scheduled caste or scheduled tribe to dispose or carry human or animal carcasses or dirty graves. So you should know that even today in the cremation grounds, the persons who handle the human corpses are not persons who belong to the upper castes. They belong to the untouchable castes. People who work in the mortuaries. How many of you have actually visited a mortuary in a non-urban setting? So as part of your discourse, apart from visiting a landfill, I would suggest you visit a mortuary. The persons who actually perform the anatomy is not the pathologist. He's sitting there and he's giving directions to a person who will slit the body open and take out those organs which need to be preserved. That person belongs to a certain caste and a certain community. And you might find very often such person to be inebriated. Just like sewer cleaners are in fact invariably inebriated. They need alcohol to be able to take the level of stench, because it's not just one body they are slitting open, right? Several bodies in a single day, and then stitching them up again after the postmortem is done. So all of this is performed by a certain community. So which is what this is all talking about, this section 3. Performs or promotes dedicating a scheduled caste, scheduled tribe movement to a deity. So the Devadasi system and forcing women into prostitution through this method is something that's treated as an atrocity by the legislature. It also talks about preventing scheduled castes from casting votes or filing nomination papers. This is also important. Corrupts or fouls the water of any spring, reservoir, or any other source ordinarily used by the members of the scheduled caste, so as to render it less fit for the purpose which it is ordinarily used. And then it also talks of compelling them to clean toilets and other places of such use. So there's a whole listing out in section 3 of the Prevention of Atrocities Act of dignity violating practices. So in the context of the Indian society, we should have no difficulty in identifying baseline violations of dignity, unlike what you might read in the literature around this topic. So just to refresh our memory on the case law, I spoke about Sunil Batra, which is about placing fetters on prisoners in standing position. So if you look at the Sunil Batra 2 decision, you will find in the concurring opinion of Justice D.A. Desai, he is adverting to the visit to Tihar jail by the judges of the Supreme Court. This is one of those rare instances where judges went from Tilak Marg into Tihar jail. I'm not sure even today they do it. And they saw for themselves what Sobraj had talked about in his letter petition to the Supreme Court, that they were being forced to keep standing with fetters around their ankles and wrists. So what you see about Abu Ghraib, for instance, those videos are there, Guantanamo Bay, which is happening even today, straitjacketing, waterboarding, all of this, the treatment of prisoners was talked about way back in 1978. And in the Nandini Satpathy case, which was about the rights of women not to be forced to attend a police station after sunset, there's a clause to that effect in the CRPC, and I'm sure in the new avatar of it. Justice Krishna actually uses the word third degree and says that is not a permissible means of interrogation at all. So we're talking of 1978. And it is no different in 2025. It is still the only, not only, the most prevalent tool of investigation for the Indian police, subjecting people to torture. So even when an anticipatory bail application is moved in our courts, you will find the prosecutorial team, the assistant PP or the PP, actually tell the court that we need custody of this person for custodial interrogation because he is not cooperating. So these are the standard words and phrases used. So as judges and lawyers appearing before judges, everybody knows what this means. When you say custodial interrogation, it means torture. When somebody says he's not cooperating, it only means that he will cooperate only if he's subjected to torture. So torture is internalized. So although you have 3 new laws now, they're called new, but they're only new in form, not in substance. We don't have a law against torture. We have not ratified the Convention Against Torture and all the indignities that accompany torture. Torture is a pure form of physical violence is one thing. But torture in various forms which affect your dignity is another. So recently I was arguing a case for the persons accused of the bomb blasts in Mumbai of 2007, train blasts. And this was under the quota. And admissions can be made before, so-called confessions can be made to a senior police officer. So police officers have their own reputation. So within all the Mumbai police stations, there is one who has acquired a notoriety. He's notorious for being able to torture victims, torture suspects, and get the truth out. So even when the police station, the policemen of a particular police station are torturing a particular suspect, they warn him that if he does not admit to the crime, he will be sent to this particular police station for proper treatment. So all this comes out in the testimony of these people who were accused who stepped into the witness box. So we now have testimonies by prisoners talking about how the wife and mother of the prisoner was brought before the prisoner and stripped of their clothing. So as part of this custodial interrogation are these practices of indignity, urinating on a person, forcing a person to drink urine or eat excreta. These are all parts of the custodial interrogation techniques. I don't know how many of you have read about Guantanamo Bay and Abu Ghraib. And that should be compulsory reading anyway. This US Senate report, which has been discussed elaborately in a US Supreme Court judgment, and the opinion of Neil Gorsuch is very telling about what kinds of practices were deployed. So you begin to understand that baseline violations of dignity appear in various settings. So in the criminal law setting, it's not about the physical torture part of it, which is easier to understand from a legal perspective, but the indignities suffered by a person facing interrogation that requires our peculiar attention. The Bandhua Mukti Morcha case and the PUDR case are very important cases for understanding Article 23 of the Constitution, that is forced labor, begar. So the Supreme Court has actually said offering less than minimum wages to a laborer is violative of Article 23, even if that laborer doesn't complain. Because one of the arguments put before the Supreme Court was, this person is not complaining, what's your problem? So Justice Bhagwati had to explain that Article 23 cannot be waived. There cannot be a waiver of fundamental rights. I found this one passage in this judgment which goes by the name of Shankarlal Gyarsilal Dikshit versus State of Maharashtra. It's a regular criminal case. The Supreme Court is acquitting a man who is charged with committing rape and murder of a 5-year-old girl child. And the man is visibly a poor person with very little or no economic means. And the senior Chandrachud, this is a judgment written by Justice Y.V. Chandrachud. Towards the end of the judgment, he talks about the prejudices that the villagers had against this one person who was a man of poor means. So I'll just read this passage. The folks of Karanja, this is the village Karanja, had a grouse against the appellant. He had made a nuisance of himself to his family and friends, neighbors, and tenants. The small world of Karanja was up in arms against him. He had assaulted his mother and a brother a few days before the incident. He had a quarrel with Sheelabai, his tenant, on the very day of the incident. He was an idler and had no means of livelihood. The description of his clothes at the time of his arrest is an eloquent commentary on the way of his life. He was wearing 2 full pants, one on top of the other, not because he had one too many to wear, because one of the 2 pants was torn at awkward places and he had to hide his shame. It was torn both on the hips as well as the center. The left leg of the pant was torn over 2 feet and the right leg over half a foot. The shirt on his person was torn all over. The right arm of the shirt was hanging precariously by the rest of the torn portion of his shirt. The Karanja community must have heaved a sigh of relief that a person who was so good for nothing was ultimately in the hands of law. Such people have no partisans, but that does not mean justice can be denied to them. So without using the word dignity, it's such a powerful passage. And I remember when I had not even started doing law, by pure accident, it's a story for another time. I happened to pick up this book and accidentally read this passage and struck me so hard. Until date, this is what we mean by compassion. If a judge refuses to see this, and I would urge as a law student, if you refuse to see this, you're not a person to be doing the course on right to dignity. So this is what you need to recognize, what Indian society is all about. So if you want to understand the dignity tropes, one is to pick up the law and poverty trope, right? Begging is still an offense in many states in the country. It's been illegalized in Delhi. It's been struck down in Jammu and Kashmir. It's not struck down in Gujarat. It's not struck down in Bombay. It's called the Bombay Prevention of Begging Act of 1961, which was applicable in Delhi. It's been struck down in Delhi, not in Bombay. So today, under that act, a vagrant is defined as a person without any visible means of sustenance. So the passage I just read, wearing 2 pants, one over the other because the other pant is torn at awkward places, wearing a torn shirt. And if you're wandering in the street or even standing in the street corner or sticking out your hand, you're a person without visible means of sustenance. So the social welfare department has its teams to conduct raids. They can pick you up and take you before a magistrate who will remand you to the beggar's home. So you enter the criminal justice system and you're in a penal custodial institution from which you cannot exit. You can exit under these rules, under this act, only if you give a bond assuring that you will not beg, which is so ridiculous. The man was, first of all, brought into your system only because he had no means of sustenance. So this is something that we need to constantly, fight against. Criminalizing acts of poverty. Likewise, sex work is criminalized, as if the woman has a choice. So the mere act of standing outside a doorway and soliciting customers is an offense. That very act, you don't have to actually have a customer. If you're found soliciting with sin, a wandering mentally ill person is brought into the criminal justice system, even under the Mental Health Care Act. So all activities of the poor, sleeping on the pavement can be an offense. Encroachment, illegal occupation of public land arising out of poverty. So all these are invasive of human dignity in the first place. On top of it, you criminalize it. So understanding dignity to the trope of poverty is another very useful trope in the Indian context. You will not find much literature on this, but I would urge you to read Barbara Harris White. Some really powerful writing has been done by her on this. And of course, Upendra Bakshi. So one judgment of the Delhi High Court, which is less noticed, and you will find this discussed in detail in Usha Ramanathan's article on ostensible poverty and beggary. If you go on Google, you will find this article. She discusses this judgment in great detail. It's a judgment of the Delhi High Court in Ram Lakhan versus State. It's a 2006 decision. So the conviction under the Bombay Prohibition of Begging Act was set aside by the Delhi High Court in a criminal revision petition. And the judge notes, it's very, very interesting. This is Justice Badr Ahmed. Unfortunately, it's not a reported judgment, but it's discussed in detail in this article I just mentioned. He observes all of this. He says the Metropolitan Magistrate had recorded that, and I'm quoting, the accused was begging by raising his front paws, PAWS, paws from the passers-by. It moved the irate judge, the irate judge is Justice Badr Ahmed, to exclaim, beggars are not beasts with claws. They are human beings and they should be treated as such. For any civilized society, the judge observed, to have persons belonging to this category is a disgrace and a failure of the state. To subject them to further ignominy and deprivation by ordering their detention in a certified institution is nothing short of dehumanizing them. Prevention of begging is the object of the said act, but one must realize that embedded in this object are the twin goals. Nobody should beg and nobody should need to beg. So this judgment is all about dignity. It may not use the word dignity, but this is how judges are expected to respond by recognizing inherent dignity of individuals. But unfortunately, this is not being consistent across the judiciary. And these kind of cases come in before the judiciary very rarely. I've talked of this entire trope of Nas, Nalsar, Puttaswamy, Navtej Johar. I'll just read this one formulation in the majority judgment in Puttaswamy. Privacy of the individual is an essential aspect of dignity. Dignity has both an intrinsic and an instrumental value. As an intrinsic value, human dignity is an entitlement or a constitutionally protected interest in itself. In its instrumental facet, dignity and freedom are inseparably intertwined, each being a facilitative tool to achieve the other. The ability of the individual to protect a zone of privacy enables realization of the full value of life and liberty. So there's a recognition of both the facets of dignity, which is the respect of the person and treating the person equal, or conversely not discriminating against the person. That is one facet. And recognizing the autonomy or agency of the person. These are two facets stemming from the value of dignity itself, and both have been recognized in this privacy judgment in Puttaswamy. I now move to the three major cases very shortly. First is the Delhi Jal Board versus National Campaign for Dignity and Rights of Sewerage and Allied Workers. It's a 2011 judgment of the Supreme Court. I was part of the bench in the Delhi High Court, which decided to award compensation for sewer cleaning deaths. I just spoke about sewers. Actually, people enter physically into the sewer, and there's enough documentaries now available in YouTube on all of this. And they go without any protective gear. Many of them die of asphyxia. And it continues till date. There are many of them employed by municipal corporations, but through the device of outsourcing, because the corporation does not want to take responsibility. So it was that context we were faced with. When we asked Delhi Jal Board, how can you allow this? They said, no, we ask contractors to do it. We don't do it ourselves. So try to wash their hands off, which we didn't allow them to. Fortunately, our judgment was affirmed by the Supreme Court. And this is what the Supreme Court said. It is the duty of the judicial constituent of the state, like its political and executive constituents, to protect the rights of every citizen and every individual and ensure that everyone is able to live with dignity. Given the option, this is what the Supreme Court says, given the option, no one would like to enter the manhole of sewage system for cleaning purposes. But there are people who are forced to undertake such hazardous jobs with the hope that at the end of the day, they will be able to make some money and feed their family. They risk their lives for the comfort of others. Unfortunately, for the last few decades, a substantial segment of the urban society has become insensitive to the plight of the poor and downtrodden, including those who, on account of sheer economic compulsions, undertake jobs, works which are inherently dangerous to life. People belonging to this segment do not want to understand why a person is made to enter a manhole without safety gears and proper equipments. They look the other way when a body of a worker who dies in the manhole is taken out with the help of ropes and cranes. In this scenario, the courts are not only entitled, but are under constitutional obligation to take cognizance of the issues. This was in 2011. We have two statutes. One is called the Employment of Manual Scavengers and Construction of Dry Latrines Prohibition Act, 1993. Because we have a practice of dry latrines in this country. Those dry latrines are cleaned by untouchables, and a majority of them are women. So there's a documentary which goes by the name of I Am Dalit, How Are You? So you can make a note of it. It's all there on YouTube. The second statute is Prohibition of Employment as Manual Scavengers and Their Rehabilitation Act 2013. You will find very little courses specific to all these statutes that I'm talking of, whether it's the Prevention of Beggary Act or these statutes. They will be at the best part of a social justice, module or something, I suppose. But I think taught less and less in law schools these days. And many of you may not opt for it because this is not going to look good on your CV or not give you entries into corporate law firms. It will probably categorize you as being left of center. And, you have a phrase for all of this. Jholawalas. Have you heard of that? Murli, you would know it. So it's very important for us to acknowledge what the parliament has acknowledged. Now, these two statutes, like many other statutes, have not been implemented. That's a long and short of it. So we had to file a class action litigation, which goes by the name of Safai Karamchari Andolan versus Union of India. It's a very important judgment of 2013. So we collected a large volume of data. I became a judge in 2006. I had started the PIL in 2003. So it was continued, fortunately, by my associates. And a large volume of data was presented to the Supreme Court. And the court noticed that these two statutes are relatable to Article 17 of the Constitution. And the court then said for each death of a sewer worker, there should be a compensation of 10 lakhs given to the family of the deceased. And a whole slew of directions. People released from managed scavenging should not have to cross hurdles to receive what is the legitimate due under the law. I want to point out to you that a majority of people working in dry latrines is women. The majority of those cleaning sewers is men. Many of them have lung diseases naturally, and many of them are alcoholics, not surprisingly. So they have very short spans of life. There's no question of any insurance, no health insurance, nothing, no security of tenure. So these are the people who actually cease to work. You will have a health hazard in the city. And their value, there's no value given to their work, which is really the true irony of this whole thing, right? If young children stop picking garbage in those landfills, you have a crisis on hand. They're actually segregating degradable from non-degradable waste. It's a skill. And you have a 5-year-old or a 4-year-old doing this in those landfills. And it should not be done by a child in the first place. And it's hugely underpaid, not even subsistence levels. So these are the questions we really need to raise. So studying the law around dignity is one thing, but doing something about it is very important. Raising awareness about it is something very important. And you can do so much through your university clinics that you have. Take it up as a project. Visit the landfills in Hyderabad. Find out how children are surviving all of this. Sewer cleaners in Hyderabad. The state is always in denial. And it's not just about corporations employing these people. Private houses. You have so many unauthorized colonies in Hyderabad, right? You have septic tanks. They can't get regular connections to the sanitary system. Those septic tanks are cleaned by whom? By actual human beings. We're not deploying some machinery for that. And they go in without any protective gear. So this is something that needs attention. So it didn't stop with this. The third judgment is Dr. Balram Singh, which is a 2023 judgment. What is important in this judgment? It recognizes Articles 15(2), 17, 23, and 24 of the Constitution as in what it calls as emancipatory code. These were the provisions which were meant to bring about social transformation through law. But Ambedkar very early on recognized that without social democracy, all this talk of democracy is meaningless. So if you go through his speeches in the Constituent Assembly, you will find the pain and anguish coming forth again and again, where he says it's like a top dressing on a loose soil, right? Democracy is a top dressing on a loose soil when he's talking of constitutional morality. Because if as a society we don't practice it, you're not going to see the transformation. And it is for us who are not doing that job to do it. So this passage in this Balram Singh is very powerful. This is what Justice Ravindra Bhatt says. If we are to be truly equal in all respects, the commitment that the constitution makers gave to all sections of society by entrenching emancipatory provisions such as 15(2), 17, 23, and 24, each of us must live up to its promise. The union and the states are duty bound to ensure that the practice of manual scavenging is completely eradicated. Each of us, this is the horizontality, each of us owe it to this large segment of our population who have remained unseen, unheard, and muted in bondage, systematically trapped in inhumane conditions. The conferment of entitlements and placement of obligations upon the union and the states through express prohibitions in the Constitution and the provisions of the 2013 Act mean that they are obliged to give real meaning to them and implement the provisions in letter and spirit. And this is the important line. Upon all of us citizens lie the duty of realizing true fraternity, which is at the root cause of these injunctions. Not without reason does our Constitution place great emphasis on the value of dignity and fraternity, for without these two, all other liberties are chimera, a promise of unreality. It is all of us who today proudly bask in the achievements of our republic, who have to be awake and arise so that the darkness which has been the fate of generations of our people is dispelled, and they enjoy all those freedoms and justice, social, economic, and political that we take for granted. Now, in the context of the Sabarimala case, for those who may not be aware, I'm sure all of you are aware, because this is something that law schools have discussed threadbare. The problem was barring the entry of women between the ages of 10 and 50 into the Sabarimala temple. Curiously, this ban was imposed in 1991 by the High Court. So two judges of the High Court took it upon themselves to say they are barring the entry of women. So till then, you had instances of women going there. In fact, there was a woman collector who went there. Some film stars went there. A film was even shot there. All this happened. Suddenly, in 1990, one person went to the High Court in Kerala, and two judges of the Kerala High Court agreed with that person. It said male, and said yes, we are barring the entry of women between 10 and 15 to the Sabarimala temple. Then you have rules made under the temple entry statute, which actually incorporated this ban. It is very strange. So they're using the law under 25(2)(b), which is supposed to open up places, to place a restriction on women entering, which is what led to the filing of the petition in the Supreme Court. So you had a split verdict, 4 judges agreeing with the petitioner that barring the entry of women between the ages of 10 and 50 was illegal. And in developing that argument, Justice D.Y. Chandrachud talks about dignity. So here he says, exclusion is destructive of dignity. To exclude a woman from the right of worship is fundamentally at odds with constitutional values. Then he also picks up the untouchability trope, because one of the arguments was menstruating women will defile the sanctum sanctorum and make it impure. So an argument of purity was brought in, and that was negative by saying the menstrual status of a woman is deeply personal, an intrinsic part of her privacy. The Constitution must treat it as a feature on the basis of which no exclusion can be practiced and no denial can be perpetrated. No body or group can use it as a barrier in a woman's quest for fulfillment, including in her finding solace in the connect with the Creator. And he treats this as a form of untouchability. And he develops a whole narrative, which then comes into Sukanya Shanta. I find that he's picked up that whole narrative and developed on it in Sukanya Shanta judgment. Because what happened to the Shabarimala judgment, you know very well. The presiding judge was Justice Deepak Mishra, and this was on the eve of his retirement that this judgment was delivered. When the review petition was filed, Justice Deepak Mishra was substituted by Justice Gogoi. And while two of the judges, Justices Chandrachud and Nariman, stuck to their original view, Justice Khanvilkar, who was part of the majority, changed his view and now sided with those who said the judgment was reviewed. And this is all within a matter of a few months. So it's a very powerful dissent that you will find by both Justices Nariman and Justice Chandrachud in the review order. Strangely, the majority in the review referred the matter to 9 judges. And now it's before a 9-judge bench. So the next judgment you will find in that is the Kanti Veera Raju judgment, which is on the maintainability of that reference. They have not actually answered the real question that has been referred to them, because it is also supposed to consider questions of law which would have bearing on the pending writ petitions relating to entry of Muslim women in dargahs. So this is what I meant by spanning all religions, right? Indignities heaped on women by denying them entry into places of worship, not just for Hindu temples, but also Muslim places of worship in dargahs and mosques, and entry of Parsi women married to non-Parsis in the holy fireplace of Aghyari, and the challenge to the practice of female genital mutilation in the Dawoodi Bora community. So all these questions are pending before the 9-judge bench. We don't know when they're going to answer it. The third, this is the last, is the Sukanya Shanta judgment. Again, I think it's been discussed threadbare. Basically, Sukanya had covered in a series of articles in the Wire the practice actually being followed in many Indian prisons of segregating prisoners according to their caste. So in Palayamkottai in Tirunelveli district in Tamil Nadu, a separate prison, the Tevars, Maravars, and the higher castes are kept in separate prisons. The ostensible reason is if you keep them in the same prison, there will be violent clashes. But the real reason all of us know is segregation for the purposes of work in prison. So much of the work within the prison is performed with prisoners themselves. One of the work is, of course, cleaning toilets. So toilets are cleaned by Dalit prisoners. So segregation of prisoners for the purposes of work, and it's written into the prison manuals. This is what is remarkable. It says cooking will be done by upper caste persons. Cleaning will be done by people habituated to that. So these provisions were declared illegal. Fortunately, the case has been kept back in the court for monitoring, because we wanted directions to each of the states to take out these provisions from the prison manuals, and also to remove provisions concerning habitual offenders. Because habitual offenders were understood as persons who belong to the denotified criminal tribes in the pre-independence era. And that has percolated into all the provisions of the prison manuals today. And that's why you have a lot of discrimination being practiced within prisons against persons who are just deemed to be habitual offenders if they happen to be born into those communities. So you have many such communities like the Banjarans here in Hyderabad, the Gypsies. They're one such community. You'll find that there's a theft in the neighborhood. They'll go to this community and pick up the bales there. So these 3 judgments do help you understand how the judiciary is understood practices violative dignity. But where it all breaks down is what actually happens in the court, and I'll end with this. One is what we call the male gaze of judges. how they view women. So again, one important article which all of you should read goes by the name of Reasonable Man, Reasonable Woman, and Reasonable Expectations. How many of you have read it? So this is naturally, this is a must read because it powerfully places how judges look at women. And I don't want to bore you with too many passages from it, but the author basically says we've all known who a reasonable man is, but we don't know who the reasonable woman is. And in that context, she, after discussing all the judgments, the whole trope of judgments between 1920 and 1950, it's a period of 30 years, the author says this: the reasonable woman is a wife. She becomes one with the family of her husband. She's sexually available to her husband. She doesn't expect to be treated as a wife, only to be maintained. She's entitled to shelter and safety, though she is not entitled to stay in her matrimonial home. She has no marital honor, so she cannot encash her honor as her husband can. So you actually had adultery cases ending up in compensation being paid to the husband, because the woman is treated as chattel. She's chaste and keeps unsullied the bed of her lord, even when he deserts her. She belongs to a man, generally her father or her husband. She's married young. She does not exercise choice. She has no politics. She's incapable of being a legal guardian. So the Gita Hariharan case, if you see it from the dignity trope, you'll get to understand this even better. She does not have children. She bears her husband's children. She does not complain of rape. She's incapable of being dishonored, especially if she's of a low caste and this assault is by a high caste man. So the Vishaka judgment, the background to the Vishaka judgment was Bhavri Devi's case. One of the grounds for acquittal of Bhavri Devi was that how can an upper caste person rape a person of a lower caste? Although this article talks of judgments between 20 and 50, we find all those prejudices of the male judges have further traveled into the 20th and 21st century. A reasonable man, after saying all this, okay, the prostitute woman is not a reasonable woman, and she's not to be judged as a reasonable woman would. The reasonable man gets married and gets a dowry for it. Maybe he marries again. He chastises his wife in moderation, perhaps with small beatings, but he doesn't cut his wife's nose. He has control over his wife and his daughter. He's entitled to the custody of his wife, even if she is not yet reached puberty. If he can't have her in his possession, he has her sent away from her mother into institution. I must tell you that these prejudices have continued till date. We were having a conversation with judges from the Allahabad High Court in the Judicial Academy in Bhopal, where we were discussing of the growing trend of habeas corpus petitions by runaway couples. It's very common, whether it's Delhi or Punjab or Haryana or Allahabad, maybe even in Andhra Pradesh. It could be an intercaste, interfaith couple saying that parents of both families are going to, finish us off and we need protection. So in Delhi High Court, as a practice, routinely we would give them protection without insisting on proof of, your age or proof of your marriage and this and that. And in the next hearing, would call the parents and ask them. When the Allahabad High Court judge heard me say this, he said, no. In Allahabad, we don't do it this way. If this couple comes before me, he said, as a judge, first I will ask, what if this girl was my daughter? And he said, no parent can ever think badly for their children. No mother can ever, intend to cause harm to a child. So, you come with these cultural specific prejudices. It's very difficult to overcome that. So this clash of, the cultural orientation and the male gaze continues. The other day in Punjab and Haryana High Court, a live-in couple was denied protection. A couple so-called living in adultery was denied protection. Because judges, some male judges in the country still feel that this is all against Sanatana Dharma. So they say it in that many words. I mean, this is not left to our imagination anymore. They say it in passages in their orders and in judgments. So these prejudices, the male gaze is continued, mansplaining continues. So we have this glossary brought up with the Supreme Court. I must say it's a very difficult glossary, but it is not something that is developed in discussion with judges who have the male gaze. So for many of them, it's Greek and Latin. They say, don't show us all this. So this is really a problem in the Indian judiciary. Trial court judges, I find, are in denial of dignity violative practices. For instance, if you walk into a trial court, how many of you have been in a trial court? Many of you have. Many of you would have found that the person who's accused of a crime, not the criminal, although we very loosely say is the criminal brought into the court. The person accused of a crime is brought into the court. He has to stand before the court like this, correct? If he stands like this, the lawyer will correct it. No, 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 put your hands like this. And he'll also say, put your head down. Completely violative of the so-called inherent dignity of that person, correct? But we don't think twice. As a system, we completely endorse it and say this is the right way to be in a court. So in Orissa, when we were designing a new court complex in Bhubaneswar, the little thing I could contribute was two. One is in the witness box to have a chair. Because in American courts, no witness is made to stand. In Indian courts, a witness has to stand. The witness will behave disrespectfully if he tries to sit before a judge. Likewise, the person accused of the crime has to be standing in the corner of the room. So when we decide, we said we'll have a seating for the... And many judges said, sir, are you sure you should do this? I said, as Chief Justice, I'm telling you, you have to do it. So, because where do you start? Like lockups. How many of you been to lockups in the court? And the toilet in that lockup, have you seen it? It's an open toilet, not covered. So these are all practices, active practices, violative of dignity happening in our courts. And we're not doing much about this, not doing anything about it, in fact. So why don't we write about what our court complexes have come to signify? How many magistrates look up and speak to the person who's produced for remand? I found in Beggar's Court at that time, before the law struck down in Delhi, the man did not even lift his face. They brought a sheaf of remand papers. They had conducted a raid, picked up some 200 people outside temples, outside public places. And he did not even pause to see any of them. He did not even ask, who's this person? He's overburdened with work, certainly. But what does it do to the dignity of the person brought before him? You're not even treated as a person. You're not even worthy of a question. So within the judiciary, a lot of sensitizing has to happen on dignity respecting practices. So we may talk in various forums and academies, but when it comes to actual practice, many of us have lived comfortably, even in the bar. So you're looking for lawyers with greater sensitivity to human rights, you won't find them. It's a very, very small number. Only the Jolawalas. So even among lawyers, you have Jolawala lawyers. They're called that. So we look to you as law students to carry these things forward. See, these are all the expectations of the Constitution or the preamble. These are the promises that we made to ourselves, right, as people. If we continue to live as fractured societies, there's very little that will happen in terms of change. We will regress. And I think we've regressed very, very quickly. On the social front, we've regressed enormously. In the last 10 years, the regression has actually accelerated. We have to do something desperately to stem the rot. And therefore, I'm glad you're having a conference like this. I'm glad Professor Erin is here to conduct this workshop because it's much needed. We're not discussing this in public fora. It's not happening at all. So thank you very much. Thank you for the patient listening.